The judges of the United States Court of Appeals for the Ninth Circuit. Hear ye, all persons having business with the Honorable, the United States Court of Appeals for the Ninth Circuit will now draw near. Give your attention and you will be heard. For this court is now in session. God save the United States and this honorable court.
Well, good morning again, America. This is Stuart Ryan with the Ryan Report. And I really want to address this continuing problem, this elephant in the room that's so poorly covered by the legacy media and by most of the social media podcasts. It's about sedition. The Court of Appeals' tolerance of Trump's sedition, a term not often used, and probably I'm expanding it and using it, reversing its language. The term sedition has been used in many discussions about events where groups, and I'm talking about an individual plus a group, have attempted to violently disrupt the constitutional order. Here we have the most unusual usage in a reverse set of circumstances where we have one man inside the government attempting to rebel against its law, inciting protests in order to assert a unilateral power, bearing in mind he is guilty of having done this himself on January 6th. If we'll all remember, that was a sedition. By misusing federal laws and our Constitution, Trump is actually advocating for and acting to end our democratic republic, carrying out a thinly veiled sedition against his own and our government and laws by sending troops to various cities to incite protests upon which he then relies to exercise a power play to control the cities, altering facts on the ground to rationalize the consolidation of his power. So, should he decide to cancel the 2026 elections altogether, which is certainly not an impossibility, and even declare a martial law, which incidentally is also unconstitutional as the president is not authorized to do so, he has the physical force in place to prevent righteous protest or even rebellion against his tyranny by a hapless, unarmed, and basically innocent civilian population who have legitimate and justifiable aims to restore our working democracy and a constitutional republic. While trial courts in the federal districts continue to make orders against his tyrannical behavior, some courts of appeal, particularly in the Ninth Circuit, are not following the laws of the United States and are indulging in the toleration of Trump's rush to establish a hegemony over our people and democracy. Just watch some of the shenanigans of a Nazi Judge Nelson in the Ninth Circuit Court of Appeal hearing.
Welcome to the Ninth Circuit. Judge Bade and Judge Graber and I are glad for your timely appearance, and we know this is on a quick turnaround, and we appreciate all the hard work that's gone into it. We're ready to proceed with argument in State of Oregon, City of Portland versus Donald J. Trump, case number 26-6268. Can I ask about you? You've made a review, and by the way, I know you've asked for time. We'll give you enough time to answer all of our questions. It may take each of you over the allocated times. I wanted to ask about the reviewability because you've made an argument that this is just not reviewable by the courts, and I understand your argument to be based on Martin, which has some pretty strong language that this is expressly within the discretion of the president. Newsom didn't adopt that argument. To what degree are we bound by Newsom that this is reviewable?
This foolish and right-wing judge, Nelson, tries to open the door to a possibility that this case is non-reviewable based on a case from 1827, Martin versus Mott, 25 U.S. 19, which is about a court-martial of a citizen for refusing service in the War of 1812 to 1814, somehow suggesting that its strong language, in his words, says that a president now has inherent powers not reviewable by an Article 3 court. Absolutely preposterous. That case was about wartime. That case is not on point within our present context. Nor is it applicable because since 1827, Congress has enacted several laws defining if and when and under what precise circumstances a president can exercise his power to federalize troops, whether National Guard or military, for use in a civilian context, starting with the Posse Comitatus Act of 1878, and including the law under which these defendants, Trump, have acted, which is 10 U.S.C. 12406. So this asshole judge well knows this case is reviewable, not only under Newsom, as he asks defendants' counsel, but as a matter of constitutional law.
I have a follow-up question to that, though. We are to decide on the state of the world as it exists today. And as it exists today, one of the things that you have the burden to demonstrate here, I think, is harm, that there's harm. And if the federalized National Guard members cannot be deployed, which is the state of affairs today, what is the harm that you are suffering? I mean, even if we grant the stay right now, I guess I have trouble seeing how there is harm if nothing changes.
May it please the court and counsel, Stacey Chaffin on behalf of the plaintiffs. The president's 12406 determinations are entitled to great deference, but that deference has a limit, and that limit is this case. Where the president's determinations are untethered from reality, they cannot represent a colorable assessment of the facts within a range of honest judgment. I'd like to take first, Judge Graber, your question about what document represents the president's determination. And the answer is that we don't know. It's very unclear what document the president relied on to authorize the federalization of the National Guard. The two documents that we do have are the June 7th memorandum, which was issued in response to the escalating ICE protests in Los Angeles. That memo is specifically referenced in the September 28th memorandum from Secretary Hegseth that mobilized the Oregon National Guard. That memo that was issued not only relies on the June 7th memo, it references it, and then it also attaches the June 7th memo. But that memo was issued 4 months prior.
But you're not suggesting, I mean, you have raised an APA claim, but you're not suggesting that we need some formal order that represents final agency action by the president, are you?
Not at this time. And we're not making arguments regarding the form of the order itself. But if the president was relying on the June 7th memorandum, that was both not relating to Portland, and it's exceptionally stale by the time that the troops or the National Guard was actually federalized in September. There's a significant deficit of time.
So under your theory, then we can't consider any of the facts because the president didn't mention them? I mean, I don't know what the impetus for your argument is on that.
Well, if the president, the June 7th memorandum, if that is the basis for the federalization of the national troops, it has nothing to do with Portland. And it only had to do with the circumstances that were happening at that time in June.
Counsel suggested, though, that the social media post that said there's war in Portland and go forth and fix it is sort of an addendum, if you will, or a direction to apply the June 7th memo to Portland. What's your response to that?
Certainly, the statute doesn't identify for us the form that the president's determination needs to take. And if the defendants are relying on a social media post, that social media post still isn't, it doesn't represent a colorable assessment of the facts within the range of honest judgment. Within that document, the president references Portland as war-ravaged, which we all know is not accurate. And then it also calls Portland under siege, also an inaccurate statement. Because these are inaccurate statements, they can't form the basis of a colorable argument under 12406.
Well, that may be true, counsel, but you're not denying. I mean, what we heard from your opposing counsel is there's really not a lot of dispute on the facts. There might be dispute as to which facts are relevant. Do you think there's a dispute of facts as to what's happened in June, July, August, September? I mean, are there points in time where you think you have a disagreement on what's actually happened with opposing counsel?
I think we disagree with the framing, but I would direct this court to the district court's findings regarding those facts. The district court found that the Portland ICE facility protests were small, less than 30 people, largely sedate, and generally peaceful.
Okay, hold on. That's clearly erroneous because there's clearly been protests that were above 30. I mean, unless you're trying to limit it to certain time periods. We have evidence in the record that there were protests as much as 200.
It was generally small. And
I think there were 3 instances where it was large over that time period. But when we're talking about how to, as you say, frame the facts, can you go on to answer my other question, which is what is a rebellion, and what is the standard that we should be applying?
But the numbers are not the issue. As for these numbers, it does not matter if there were 320 or 20 or 200, because that is completely irrelevant. Did they, in fact, prevent the laws from being carried out? No. What laws were those? Could civilian law enforcement handle the protests or not? Did the protesters have a right to assemble and protest or not? Were they ever attacked by ICE or another agency with any weapons or not?
A rebellion is an open, organized, or armed resistance to an established government or an attempt to change the government or the leader, usually through violence. That is the appropriate definition that this court should adopt in this case.
And where does that come from?
The older definitions in Webster's. And I would highlight for the court that the first time that rebellion was added was in 1861, and that was shortly after the Confederacy declared independence, and the first shots were fired at Fort Sumter. And it's with that context in mind that we should interpret the word rebellion. And it certainly isn't.
What about the Whiskey Rebellion?
The Whiskey Rebellion certainly comes into play as well, but I think
could that inform our definition of rebellion, or was that the president acted under some different provision?
I'm sorry, I don't know the exact answer to that question, but I can say that the defendant's proposed definition here is so broad that it could potentially encompass a significant amount of protected speech and protest activity. In their briefing,
I mean, my concern is and that may be true, but your definition and perhaps the definition applied by the district court seems so narrow that it doesn't even comport with the vast exercise. I shouldn't say vast, it hasn't been that many, but with those incidences where the National Guard has been used or the militia has been used, it wouldn't satisfy the rebellion prong in those either.
Memo of June 7th refers to current circumstances that would justify mobilization. So what, in your view, is the appropriate time frame to be looking at for determining whether the statutory standard is met?
From a kind of larger perspective, that really is going to depend on the circumstances. And we're not asking this court to create a very specifically defined set of factors that need to be evaluated in every case. But in this case, when the president has authorized the federalization of the National Guard in Oregon, we're asking this court to look at the circumstances around when that happened.
So do we look from June 7th forward, or do we look only at September or something else?
It would make sense it's reasonable to look at around the time period when the National Guard was actually federalized. What happened in June, and we acknowledge
Isn't
that
June around the time period of when the National Guard was federalized?
It was 4 months prior, and that is significant because there can be, and there was, a very large delta between what was going on in June and what was actually going on when the president...
So could the president have, in your view, nationalized the Guard in June?
I think we'd be having a different conversation, and it would certainly be a closer call. But
And so the president loses his right to do that, in your view, because he waits to see how things turn out on the ground.
I think in the moment, the president can make the decision to manage the situation with the normal forces. And here what we have is even that situation in June. I point the court to, I think it was June 14th is probably the worst of the circumstances that happened. And that day, the threat of violence from the protesters lasted 2 hours. And it's with the use of normal forces that they could stop the kind of incursion of the protesters, push them back, and everyone kind of had the safety that was necessary with using the normal forces. That stands in stark contrast to what happened in California. In California, there was a span of 2 days where they had consistent and increasing protest activity, where they were penning down officers, throwing concrete chunks. They used dumpsters as battering rams to breach the facility. And the next day, the confrontation lasted for another 7 hours. Protesters boxed in officers, threw Molotov cocktails, mortar-style fireworks, rocks. They blocked traffic and burned a vehicle.
But that's a little bit of the irony here, is that because the president acted in June in LA, I mean, I don't know that we have I don't know, but it seems like we don't have the same level of violence going on in LA right now. But the president acted when there was violence, and you're saying, well, if you don't hit it within a narrow window, you lose your right. That just seems unnaturally constrained. I mean, what the president did was bring in 115 FPS officials, and that has quelled the violence to some degree, it seems, but it hasn't abated it. I mean, there's still violence going on, right?
Well, what we have is a finding from the district court that the federal law enforcement officers, unaided by military forces, were capable of not only quelling the violence in June, but also preventing it through September. These
So
are
I'd like to ask you about some specific facts that I don't think are disputed. So the facility was forced to close. It was inoperable for almost a month, from June 13th to July 7th. And the declarations from the director of the Federal Protective Services and the field operations director from DHS state that the facility only reopened because of a surge of 115 Federal Protective Services officers to Portland, right? So those are facts that occurred, but that the district judge didn't consider because she apparently viewed them as out of time, that this had occurred. Are those not facts that are relevant to for the president to determine the threat and whether there's a threat to DHS being able to enforce the 400 laws it's tasked with enforcing? I mean, they couldn't operate a facility. I don't know that that ever happened in LA. There were attempts to breach a facility. Here, a facility was actually closed for almost a month. And the record includes more than one, at least 2 attempts to burn the building down and vandalizing the building so that it's difficult for the officers to move in and out of the building and increases danger. And the building is now currently boarded up, and the city has told DHS they have to remove the boards. So that means the facility presumably will be inoperable again. So why is all of that irrelevant to the president's decision to federalize the National Guard?
Well, I'd like to push back a little bit on the reframing here. What we have is in early June, the facility was closed for 2 weeks.
During specific dates, June 13th through July 7th. That is not 2 weeks. It's about 3.5. And I think it's properly characterized as nearly a month. But the facility was indeed closed, but the district judge didn't consider it because it was in June. So if I understand your position, only things that happen like September 24th, 25th, 26th, I mean, a very small window of time, those are the only days that the president could have legally considered when deciding whether there was a threat to the enforcement of law?
First, I want to say that these 3 judges do not live their lives outside the bubble of the courtroom in isolation, in a vacuum, absent of factual information. They are not deaf or blind. They have seen all the photographs and video evidence of the protests. They know the truth of the circumstances just as we do. They absolutely know that Trump has been trying to incite protests, then used as a pretext to military intervention in contradiction to our historical revulsion, and protections to prevent a government using the military against a civilian population.
Well, if we're talking about the third prong, the inability to execute laws with the regular forces, that is a current temporal requirement.
Okay, so what is your basis for saying that? Because I didn't say to Newsom, but what is it? Where is it that it says there's a they talked about the facts there, which happened to include events that had occurred in the preceding days. Here, the president relied on, according to the declarations that have been presented, on the facts leading up to the order from June, July, and August and September. So there's a period of a few months where things were unfolding on the ground. And what I think you're saying is we can't consider any of that it should only be a few days. But what is your basis for saying that?
The text of the statute is the basis. So if we look at the third prong, it says the president is unable. That is a current inability to execute with the regular forces the laws of the United States.
And is that a day by day? So that, I mean, if we said forces are allowed, and then what, we come back the next day and say, oh, well, you got it under control. Now they're not allowed. Then it goes back up. Oh, they're allowed. I mean, it just seems like such a tortured reading of the statute. I mean, I'm not even sure President Lincoln would have been able to bring in forces when he did, because he'd have to wait. You know, if he didn't do it immediately after Fort Sumter, your argument would be, oh, things are okay right now. It just
What,
seems.
what is the effect of the June 7th authorizations statement that the National Guard should be performing federal functions at locations where protests against these functions are occurring or likely to occur based on current threat assessments? So does that limit how we or how Secretary Hegseth would have had to consider what was currently appropriate?
Yes, if the June 7th memorandum is part of this court's evaluation of the president's determination, it is limited by the current situations. And I would also, again, just direct this court back to the text of the statute, which there is an expectation that the circumstances are going to be evaluated as they happen. And that makes sense because these are emergencies. These are unusual circumstances that would immediately require the president's attention and response. If these are circumstances that are so significant that they could challenge kind of the fabric of our nation, the threat of invasion, they need an immediate response. And there isn't an attempt to penalize the president for waiting. There is a requirement that the circumstances as they happen be so significant that we need to federalize the National Guard. And
Well, actually, for number 3, I don't think that's true. For 3, it says the president with regular forces can't execute the laws. I mean, I'm sort of trying to figure out how a district court of any nature is supposed to get in and question whether the president's assessment of executing the laws is right or wrong.
Well, this court has already concluded that there is judicial review of that.
I understand that, but it's also great deference. And I mean, here, it has to be colorable. And so when the president comes in and says, look, we've got 115 FPS forces that aren't normally in Portland and we've had to move them, this is straining our ability to execute the laws. I don't understand how you can question the behind the scenes to say, oh, no, that can't be right. I mean, we don't have a view into what laws are trying to be executed or how they're being impinged. But why isn't that colorable?
Because it's not true. Unfortunately,
It's not true that 115 FPS forces have been there since it reopened in July?
Well, we do have in the record that a lot of the surge forces were returned before the president's announcement. So I understand that these declarations kind of, they discuss the worst of the circumstances, which I understand, but they're also written by supervisors who don't work in Portland. They're from outside of the state.
I have absolutely no idea. The district court said the same thing. I have absolutely no idea what that has to do with anything.
Because
I mean,
we were direct.
you want to focus on what's going on outside and it doesn't rise to this level. But that's not what the statute says. The statute says the president can't execute the laws. That's an internal decision making. And whether there's a ton of protests or low protests, they can still have an impact on his ability to execute the laws.
But this court has said that minimal interference isn't enough to raise to the level of an inability to execute laws. And that's what we have here. We have, yes, in June, there were more intense protests, but we have the district court identifying that the normal forces were able to manage those protests, which is within the job responsibilities of FPS generally. This is what we do. They do. You have from the declaration.
But that just seems to be the wrong analysis. And the district court did this. The district court said, well, look, people who acted violently were arrested, so everything's good. But that's not what the statute says. The statute says the president can't execute the laws. And I'm just trying to figure out why we're giving, district courts the ability to say, well, this is what I see on the outside, so therefore I'm going to transfer that onto what's going on behind the scenes. And we have declarations that say that it is impeding their ability to perform their function.
We have declarations that say we're short-staffed. We're having administrative difficulties because we don't have enough people. That is not a reason to bring the military into the streets of Portland or any other city in the United States. There needs to be something more than a deficit of employees to raise to the level of such a significant incursion into the sovereignty of a state. It needs to be more.
When
And
you
this is the
say
case.
into the streets, the deployment is limited just to the protection of federal personnel and federal property. So I saw quite a bit of that language in the motions suggesting that National Guard members would be deployed to patrol the streets of Portland, which is, I don't think the government has ever said that that is the intent. The idea is to protect the building so that can remain open.
But if
federal personnel, but
what we do have, though, is a history of a very expansive and almost strained reading from the government of the district court orders. And it would, because this authorization is to protect any federal government location, any federal personnel go throughout the city to execute whatever their mission is. And there's no, as of the drafting, there's no specific limitation that they're going to only be
But
in.
why would we enjoin it up front? I mean, I want to be clear. I'm very sensitive to the slippery slope argument that's being made here and the slippery slope argument that's being made in LA and around the country. This is something that, clearly the founders were concerned about. There's been a lot of debate about how this should be used. So I'm not trying to diminish that. It may well be that the forces are used in an improper way, but we don't have any evidence of that right now. All we have is a document that says we have a federal facility under attack, or that violence has been, forced it to close down, and we want to protect it. That doesn't strike me as a glaring overuse on its face. Now, if what happens is what you're suggesting, that they do engage in law enforcement activities, then obviously we have another problem. But that's not even what the district court found. You couldn't find it. There's no deployment at this point.
Well, certainly, we're not talking about like the violations of the Posse Comitatus Act at this point. It is a bit speculative. But what we have is, from Newsom, we know that this court has a role in evaluating the president's determinations. There is a direction that is this court's role. This is the case, though, that represents the outer limits of the president's authorities. We have, in the month leading up, not even the week, if we look at the entire month of September, the district court found there was one instance in the kind of the weeks leading up where protesters shined flashlights in the eyes of drivers. There was also,
if that's true, then I think we've got a problem, because I don't think that's what the record says. If the district court really said that's all that happened in September, then the district court's clearly erroneous. I didn't think the district court said that. I thought the district court actually detailed more than just one incident in September where flashlights were shined in the eyes.
Well, Your Honor, that's the record, though. Even if we go back to...
Well, we'll have to go into it, but I don't understand the record to be that for September. I understand it to have gone down, but not that there was one incident and that was it.
That's not us saying. There were certainly protests throughout the month of September, but they were, as I earlier mentioned, and the district court found, small, less than 30 people, largely sedate, generally peaceful. That's what was happening in September. So there was an incident on Labor Day on September 1st where there were increased protests. 125 people were involved in the activity. But what we have is the statement from FPS that they were not concerned with the group. That's at 46-1. This is the day when the guillotine was displayed.
Right.
But that's arguably protected political speech. There were 40 people who remained after the larger group left, and they did arrest a few. After that, you have September 2nd, completely uneventful. September 3rd, there was a drone flying. There was some altercations. Everything was managed. That's the consistency throughout the month of September. And there were occasions when there might be a larger number of protesters, but they were generally calm and sedate. And any of the sporadic and kind of more minimal criminal activity was appropriately handled by law enforcement resources. And that's what's supposed to happen, because the situations that we're talking about, even the situations where it unfortunately could include an assault on a federal officer, that's a crime. That's a crime that was handled. They were arrested, and I understand that the U.S. Attorney's Office had 22, they're prosecuting 22 defendants. That's how this process is supposed to work. It's not that there is a protest, there is that, and then you just send in the military. This is protected speech. And for the most part, it is calm and sedate. And it is
So
something.
the drone on, I guess this is the Wednesday, the suspect got violent and spit on agents. He was arrested and booked.
That's general criminal activity that's handled appropriately by law enforcement. On the 4th, you have 20 protesters, and then there's only 15 at 8:30. On the 5th, FPS said it was a small group with low energy, no calls for service. On the 6th, there was 50 to 60 active protesters, lots of noise. They were energized, no arrests. September 7th, 7 people, low energy. September 8th, 30 people. There were an altercation between protester and a counter protester, not against the facility. It continues, and I'm happy to go through the record.
No, this is helpful. We'll have to go through it. I mean, I don't think there's any question that it's gone down in September, but part of the problem there is it's gone down largely because of this influx of other forces, which is outside of the regular use of those FPS officials. So
Does the
it's sort of
record
like
show us how many of the extra people remain in Portland, the FPS, and how many have been sent back to?
I don't know if you heard the question. I think it was, does it show, I mean, we know that up to 115 came. Do we know how many were there of the extra FPS? Maybe this is for the,
or something. Did you not hear?
yeah, we're not hearing you very well. It's kind of getting muffled for some reason.
Well,
There you go.
okay.
There you go.
I'm right by the microphone. Does the record show, the record is in front of us, how many of the FPS officers from outside of Portland who came in remain in Portland now, and how many have been sent back to somewhere else?
I haven't been able to find the exact numbers, and much of the declarations don't have dates associated with them. So it is also very possible that those officers were sent in June and they have all returned. We have a note within the last week before the president's announcement that there was a surge of officers that came out, and then there was no responsive protest activity. And so they went back to their respective offices. And then even after, I think that they may have plussed up their numbers in anticipation of the president's announcement. But then even then there was some increased protest activity, but it went back down. And
so the answer seems to be you don't know, from that we can't know from this record. And I believe counsel on the other side said, well, they haven't all gone home, but I understood him to say, saying indirectly that some or many have gone somewhere else.
certainly a lot of them have gone. And what we also know from one of the declarations is that FPS, they respond to even nonviolent protests. This is their job. They respond to potential threats, and they would use those numbers of officers to go to any kind of that exercise of speech, just in case something becomes violent. So this is squarely within their area of responsibility. And I know we continue to talk about FPS, but we haven't even talked about any of the other federal officers that are at the president's disposal. We have a ton of law enforcement agencies under the president's control. There's referencing in their declarations to circumstances, again, that are outside of what happened in Oregon, or even if there was potentially a bomb threat. Well, we don't have anything that connects the bomb threat to these protesters. And if you do, you have significant law enforcement resources, ATF, FBI, that can respond to those potential threats. That's their job. That's what they do.
The problem that I have with this argument that I'm just trying to struggle with is, the president gets to direct his resources as he deems fit. And it just seems a little counterintuitive to me that the city of Portland can come in and say, no, you need to do it differently. Now, I understand there's a statute here, and we're going to have to review that. But this goes to the level of deference that I think the president is entitled to in these circumstances. And it's not all driven. Would you agree? It's not all driven by what we see on the streets. It's also driven to some degree by what's going on behind the scenes.